All right, everybody, welcome back to the Search and Seizure Show. I've got John Ween joining me here, one of our legal instructors, live from Santa Cruz, California. Um, so if anybody's got any questions, let's jump into it. I'll try to monitor the chat over here. If you got a question, um, raise your hand or mention in the chat, and we'll see if we can get you on here. Derek. Do you have you got a mic? If you do, Derek, I'm gonna go ahead and unmute you, let you give it a chance to talk. All right, Derek, you should be able to we should be able to unmute and go ahead and ask your question.
Sweet, can you hear me?
Yes, we can.
Perfect. So my question was, as far as like welfare check, if CPS from a different state were to ask you to go check on the welfare of the kids, let's say in a new house, and when you got there, the parents denied allowing you access to the house. Do you have any sort of legal justification for going in there based on what the CPS has been saying, or just that CPS requested or anything like that?
Do we have anything more than just a, a broad CPS request to check welfare? Like, have we got any details from this CPS about what gives them concern about the child's safety? That would be the first thing I'd want to know.
Right.
Um,
So I had that today. They didn't deny it, but I just kind of, it was like something that came to my head. They didn't give us any other information as to why they wanted us to do welfare check. They just like requested a welfare check. They had these people that they dealt with before, and then they know that they moved to our town. So they asked us to do welfare check on it. They didn't give us any other information other than that.
John, yeah, I think we're probably thinking the same thing, but what do you?
Yeah, so basically, if they're refusing entry, the only thing that you're going to be able to rely on with regard to the home is the emergency aid doctrine, right?
Sure.
And so what you would need to articulate is that you have an objectively reasonable basis to believe that an emergency is occurring. That would allow you to make a warrantless entry into the home to check places that could reasonably be related and have a nexus to that emergency. And so really it depends on what the particularity is of the information provided. And I will tell you, one of the worst cases that I ever was involved in stems from a very similar fact pattern to what you are referring to. But they gave a lot more information. And so we had an objectively reasonable basis to believe that an emergency was occurring. And so over the parent's objection, we did force entry into the home, and we discovered that there was an emergency occurring, and we were able to address it. And so if CPS is going to be reaching out for you and requesting welfare checks like this, understand you're not going to be able to make a warrantless entry unless you have specific facts that support an emergency is actively occurring in the house. And so I recommend, before you go over there, if you are anticipating, based on prior history with that family, that they are going to be hostile, uncooperative, and antagonistic, you need to make contact with that CPS worker and get it clear in your head, get it straight in your supervisor's head where you're at.
Awesome.
Yeah, I couldn't add anything to that. Yeah, I mean, we fortunately we know who our caller is. We have the ability to call them back if we need more information. But yeah, the particularity of and the degree of urgency that the CPS worker can provide is going to determine your authority here. Yep.
Awesome. Thanks, guys.
Yep. Thank you. All right. Looks like Matthew Rader is next. So stand by, Matthew. Let me get you on deck. Okay, Matthew, you should be able to hit your mic. What do you got?
Hey, how's it going, guys?
Well, very well. Good to hear from you.
Hey, so the other day at work, we had a stolen vehicle hit on one of our flock license plate reader cameras in our city. Our adjacent city is not too far from this camera, probably a mile or so. We spotted that vehicle inside of their city in the parking lot of a grocery store. Ran the license plate, confirmed that it is a stolen vehicle. It's a good stolen vehicle. It was occupied. We got out with it. We ended up releasing the occupants of the vehicle due to finding out that it was really more of an unauthorized use / civil case. But our sergeant was very concerned with the liability of, since it was since the contact was not made within our jurisdiction, whether or not we'd be held liable for it if something were to go wrong. However, the argument to that was the license plate reader within our jurisdiction caught it on camera, which we have the photograph of it being within our jurisdiction. Curious on your take of that.
Oh, obviously, so jurisdictional issues are a matter of state law. Obviously, the state determines what your jurisdiction is. There isn't, surprisingly, I think, a whole lot of case law on the constitutional issue of this. The Supreme Court has never addressed, to my knowledge, jurisdictional issues and reasonableness under the Fourth Amendment. Some of the lower courts have, and it doesn't appear, at least in the research that I've done, which isn't extensive, that as long as you have probable cause or reasonable suspicion or whatever it is that you're relying on, whatever you need to do what you're doing, jurisdictional issues don't seem to be any impediment to Fourth Amendment reasonableness. So that's if you're being sued for a 1983 lawsuit. It's probably not going to be helpful if you're being sued under state law for perhaps an assault and battery or a false imprisonment. So just jurisdictional issues, generally state law tort claims come into play. If we're talking about tort law, John, you want to add more to that? Or
Yeah, I mean, for me, that has never been an issue because in Arizona, when you are an Arizona certified peace officer, your jurisdiction is the entire state with regard to your reservations, right? And so really the issue for us was, am I citing them into the correct court? Other than that, we had no jurisdictional issues.
And that's one easy way the state can resolve it by just granting statewide authority. Virginia, we don't have that. In Virginia, you only have jurisdiction in the territory you're sworn to protect. And now we have, there's mutual aid agreements and citizens arrest authority, but this is going to be heavily dependent on state law and how far your jurisdiction extends. But as a Fourth Amendment matter, I don't think jurisdiction is going to come into play.
Absolutely. You are a government agent.
Correct. Yep. Matthew, you found that helpful? Hopefully that gave you a little bit of guidance. If he's still here, he might not be here. Okay. All right. Let's see who we've got next. Ryan. Mine's at work, but he's got a question. So let's get Ryan. Hold on a second, Ryan. Ryan Moritz, you are now able to talk.
Can you hear me?
Yes, we can.
Okay. Got a quick question on like apartment buildings. How much authority does a apartment manager, building owner have in the common areas of an apartment building? Like as far as trespassing people from there and controlling access for who they do or do not want in there that doesn't actually live there.
Are you talking about so what kind of common areas are we talking about? Like outside, like playground or hallways within the building? Because I think
Hallways within the building. So usually it's usually hallways within the building. And maybe common areas like wash or the laundry rooms and stuff like that.
And is this person a guest of a tenant that we're wanting to ban?
Sometimes they claim to be,
Mm-hmm.
but they're usually just hanging out in the common areas. And then, of course, they cause problems, and building management sometimes gets involved, and they state that they're not welcome there anymore. But if they are visiting a tenant, how much authority would they have to prevent them from visiting a tenant?
I think if they're just there hanging out, not with any particular tenant, it's an easy one. They absolutely can ban them from the property as the agent of that property. I think if they're just visiting a tenant as a guest, if they're not violating any rules or lease conditions, I think you might have a hard time saying that manager has the authority to ban them from the property. I think we might be infringing upon some of the tenants' tenancy rights, the right to have visitors, but
Right. And usually where it comes in with us is more of a, hey, I'm here to see Dave in 302, and Dave in 302 isn't there. And they're adamant that they're there to visit a tenant, but we've been there multiple times for the same person. And that's their excuse all the time, is they're there to visit Dave. And now the apartment manager has been involved because they've been had complaints or whatever. And now they're like, well, he's not allowed to be in this. I don't want him in this building anymore, especially in the common areas. And of course, to visit Dave,
Dave
you have
isn't there. Dave isn't there. Dave might not even know this guy, right?
right.
Sounds like a trespasser to me. What do you think, John? Kick him out?
Yeah, I would agree. I think under the facts as you are presenting them, yeah, he can be arrested for trespassing, assuming the motel or the landlord, rather, the property manager is willing to aid in prosecution, willing to, be a victim of that.
Sure.
I mean, we had this situation that frequently occurred is we would have property managers who want people trespassed who are not living there, but then they are coming to visit friends. And so then the idea is, can a property manager trespass an occupant's friend? Well, no, because they have the ability to have their friends in their apartment with them. The issue is, of course, they have to pass through common areas to visit their friends, right? And so then
Right.
we would have property managers call us and say, oh, well, he's trespassing. He's on the trespass log and he's walking up this path to go visit, and so we did not take enforcement action in those circumstances. We said, if you don't want this person who is visiting one of your tenants to be on your property, then you need to go through the eviction process for your tenant. Conversely, if we had people who were hanging out in the common areas who had previously been trespassed and were not actively there visiting tenants, then we had no problem arresting them.
Okay. That's kind of where we stood with it. I was just curious what everybody else's opinion was on it. Um, we don't go around if they're in a beeline from point A to point B, and which is Dave's apartment. We never really, we told them, hey, we don't really have a whole lot of say on that because they can invite guests. Even though the building management is tired of these people and wants to try to attempt to clean it up, because a lot of our apartment complexes are full of, we'll put troublemakers, I guess, or problem tenants that we have.
I think that's a good practice.
Yeah, and a lot of leases have, provisions where if you can't have guests there that are violating the law, but that's an action against the tenant for violating the lease. So yeah, if they're just visiting and they're traversing the route to the apartment unit, I think there's not a whole lot of enforcement action that we could take.
Okay.
Yeah, I agree.
Appreciate it.
Uh-huh. Let's see. Who is
79. I'll be out at CMG for just a moment.
who we have next? Let's see. Jacob Wilhelm. All right, Jacob, stand by. Jacob, you can go ahead and unmute your mic and ask your question.
All right. Can you hear me?
Yes, sir.
Okay. So my question is, if you have reasonable suspicion to believe an infraction, such as a vehicle code occurred, though it was not in your presence, can you still entertain that reasonable suspicion, detain, and investigate? Understanding you might not be able to enforce it at the time as the original violation was not in your presence.
So I know the Ninth Circuit, and John, you correct me if I'm wrong here, has held that you can't make a stop for a reasonable suspicion for a minor infraction that has been completed. Am I
Yeah.
following the case law correctly, John?
To my knowledge, what is an infraction? We're weighing the governmental interest against the infringement on the individual's rights, right?
Yes.
Your government has come out and said, I don't care. It's an infraction.
Cool. Appreciate it.
Yeah. Yeah. Yeah, unfortunately, yeah, for completed low-level misdemeanors, there's significant amount of case law says, yeah, that you can't stop them. There's not to say you can't investigate it in other ways and go get a warrant for their arrest, but yeah, just a detention to investigate a completed low-level infraction is probably going to be unreasonable in a lot of circumstances. All right, Lucas has a question. Let's see. Let me get Lucas.
We also need to get Gregory Friend.
Gregory Friend. Okay, Gregory, you're on deck. I apologize. Lucas, you're up, and Greg's on deck.
Alrighty, can you hear me?
Yes, Lucas, go ahead.
Alrighty, so this is a scenario-based question that me and my team ran into yesterday, actually. So S1 has an active arrest warrant for his arrest. He does not have any status for searching, so he is not on probation or parole. S1 lives with his girlfriend, who is not wanted and is also not on probation or parole. Officers arrived at S1's residence, and S1's girlfriend refused to answer the door, but officers could hear S1 in the back of the apartment. Officers forced entry and ultimately took S1 under arrest and did a search incident of arrest of him. They also did a protective sweep of the residence and found 2 firearms in plain view. Our question was, ultimately, do we need to seek a warrant to verify the serial numbers of these firearms to verify if they are stolen or not? We conducted a search of both people, and neither one of them had firearms registered to them.
What was, I think I missed,
Here,
what was,
I have it typed out. I'll put it back. I'll put it in the chat.
Okay.
Just in case.
and, okay, yeah, why were, okay. He has an arrest warrant, okay,
An arrest
And-
warrant with no status.
okay, and he lives there. It's his girlfriend's residence, but he lives there, right? He
He is on the
resides
lease.
there currently.
Correct. And we checked with the apartment management, which is,
Okay.
and he is on the lease.
And while we're at the door talking to girlfriend, we can hear what we believe to be him inside. Is that correct?
Correct.
Yeah. So the entry is lawful for Fourth Amendment purposes. You have a warrant, an arrest warrant for a person you reasonably believe is there, and importantly, reasonably he lives at that particular location. So the entry to look for him would be lawful.
Correct. Our question is the serial numbers on the firearms.
And they were discovered during a sweep of the residence after the arrest.
Yeah.
So the sweep of the residence is going to require a reasonable suspicion to believe there could be other people in there that could harm you during the arrest process.
Correct.
Do we have that? Do we have this? I wasn't there. I'm asking.
So ultimately, one of my partners was in his social media, and he has been seen with firearms in the past. When they were going to arrest this person, he was retreating to the back room, and they ultimately caught him before going to that back room.
Okay.
They ultimately did a protective sweep to make sure that there was nobody else in there, because at the time they couldn't say for certainty that there wasn't.
Okay.
And we don't know for sure that the voice we heard was him talking right at the door. I mean, it could have been someone else, right? My point is, it could be reasonable. There could be another male in that house.
They strongly believed it was him, but there was always that chance of error.
Right.
Okay.
So basically, Lucas, what we have here, right, is we've got 3 types of protective sweep when we make an in-home arrest, right? Maryland versus Bowie, Schimel versus California. We're talking about search incident custodial arrest of him in the immediate surrounding area, right? And that's to
Correct.
prevent him from gaining access to weapons affecting a means of escape or destroying evidence. I can also do a protective sweep, checking adjoining areas, those areas that are, immediately adjacent to the in-home arrest. I can look for people in people-sized places. And so if I arrest this guy in the living room, I don't have to stand and body block a bedroom door and hope nobody shoots through the bedroom door and hits me in my chest plate. I can pop that door and go into that room and look for people in people-sized places. if I want to do a protective sweep throughout the entire residence, again, looking for people in people-sized places, that requires articulation. That is going to require me to convince a court that I have a reasonable basis to believe that there are dangerous Confederates inside the home. And so based on the facts that you are giving me, I do not have that. If there are additional facts that say, yeah, I have reason to believe there are dangerous Confederates, not just he's got guns, because I'm not looking for guns, right? I'm looking for
Mhm.
dangerous Confederates. And so if I check those adjoining rooms immediately adjacent to the arrest, those areas from which an attack can be immediately sprung, and I see plain view firearms, then I'm all good with that. And we can seize those while we're effecting the arrest. All right. Ultimately, your question is this, right? Is if everything else is good, right? And I'm gonna move forward under your fact pattern is everything is good. I checked immediate adjoining areas and I found weapons in plain view. I looked for people in people-sized places and I found weapons in plain view. The question is running those serial numbers an additional search that requires some level of justification? Is that a fair assessment of your question?
Yes.
Okay. And so I'm going to tell you, I do not believe it is. Now, if you want to get dirty with it, we can, and we can say, are the firearms inside holsters such that I have to physically manipulate them in order to see the serial number?
The guns were just outside of holsters, laying on the ground.
Great. So, I think Arizona versus Hicks is going to be your controlling case here. And basically, in that case, officers were validly inside a guy's residence in response to a welfare check, right? An emergency aid doctrine, let them in the house, got them in the apartment. And while they are so engaged, they look over and they see in this entire, crap hole apartment, he's got this really brand new, beautiful stereo. And so one of the officers walks over, lifts it up, runs the serial number, and confirms it's stolen. And the United States Supreme Court, rather, excuse me, said this is not plain view. Why? Because he had to manipulate the stereo, which stands to reason that had the serial number been plainly visible on top of the stereo and they had run it, that would not have been a Fourth Amendment implication. That would have been plain view. And so if you can see the serial numbers of these firearms and you are lawfully in possession of them while you are effecting this in-home arrest, you can run those serial numbers and it is not an additional search.
Okay. Thank you.
Okay. Now, I'm gonna just throw a caveat out there. There is an Arizona case, and I'll try to find it and throw it in the chat that says running the serial numbers is an additional search. I very much disagree with that decision, and I think that that is legally inaccurate.
Okay.
Especially when the only information you get is whether the weapon is stolen.
Hmm.
Or even if which you have, I would think you have no expectation of privacy in that information. And even if it's a registry state where you determine who owns the gun, I mean, it's not reasonable to think the government isn't going to access that information from time to time if they require you to provide it. So, yeah, I think either way you cut it, it's not a search in the Fourth Amendment sense of the word to see or access the information that's associated with that serial number.
Okay. Sounds good.
All right, good question. Thanks. All right, Gregory Friend, you're up. You are now able to talk if you're still with us. You can unmute your mic and ask your question.
Can you hear me?
Yes, sir.
All right. Hey, appreciate everything you guys do. The shows are great. My question comes basically more of a generality of conflicting local laws and that conflict with state laws. So the example we have here is early last year, California enacted the Freedom to Walk Act, and basically it said that it's still illegal to jaywalk and cross roads outside of crosswalks, things like that. However, they added another subsection that said it's illegal for a peace officer to stop someone for that violation, unless there's a reasonable person would, and not an officer, but a reasonable person would think there was a imminent threat or imminent crash that would occur. So if there's no collision, can't stop. Earlier this year, and we're very recent this year, local council passed a ordinance, city ordinance that did not allow pedestrians to stand on medians and be in roadways soliciting for, donations, peddling goods, things like that. So basically street vending. There's confliction and there's confusion within the department right now is if what jeopardy does the officers put themselves in if they stop someone for that municipal code because they did not put that language in the municipal code about the imminent threat of a collision. Are we bound by the state standard or are we bound by the city standard as far as search and seizure goes?
Well, so I'm by no means an expert on California statutory law. I've taught there many times, but I'm definitely not well versed in it. But it doesn't sound like one's a jaywalking prohibition. The other is a standing in the middle of the street peddling goods prohibition. So I don't think there are two different kinds of conduct that are being addressed with the statutes.
Well, essentially, they're going to be pedestrians in the roadway. Is going to be the violation that you would cite the person for. Is the violation they're telling us that would be the citation would be the vehicle code section for pedestrian in the roadway for the violation of that.
Oh, I see. So the charge for that person is the statute under state law that says you can't make it a primary stop. Interesting.
Right.
Why don't they just put a sanction, a criminal sanction or penalty sanction under the ordinance and just to be done with it? I don't know. That's interesting.
Right, but I just didn't know if we were running into anything where if the state says the pedestrian can be in the roadway as long as they're not causing a collision, and the city comes back and says they're not, are those conflicting, or are the officers going to be good to enforce that municipal code by itself without the state statute being?
Yeah, Gregory, this is a great question. This is fun, isn't it?
Yeah.
They're putting you in what's called a jackpot.
Well, yeah. Not to mention the biggest culprit or the biggest intersection we're talking about, 6 lanes either direction. So
right. So here's what I'll tell you, and I think Zach's point is a good one because I think he and I were on the same page. If you have a city ordinance that says you can't stand in the center median, well, that has nothing to do with the Freedom to Walk Act, right? Obviously, you cite them for violating the city ordinance, but then you turn around and tell me you can't cite them for the city ordinance. What you cite them for is the state law that previously the Freedom to Walk Act has said officers cannot cite you for unless you are going to cause a collision.
Well, I think the ordinance is within the Freedom to Walk Act as the statute for the vehicle code that allows the local authorities to adopt ordinances prohibiting pedestrians crossing roadways other than crosswalks has that language in about not being able to stop them. So it seems like it's there, but it's also not there. So just as far as exercising caution, if an officer were to stop citing that Unicode, could they be expected to know that state code? And are those two related, or are they both freestanding ordinances? I guess is my question when it comes to seizing that person, detaining that person for one violation that seems like it contradicts another.
So again, I would have to read them, but if I can cite them for the city code, then I am not citing them for the state law. Is that correct?
Right, but the state law that authorizes the city code is arguably got the same language in it. So they just didn't put that language in the meeting code.
Right. The same language I think is irrelevant. What the Freedom to Walk Act is saying is that you can't jam people up for the violation of the, is it civil traffic code? You can't jam people up for the civil traffic code. It doesn't say you can't jam people up for your own city ordinances.
Okay.
Yeah, I agree with what John said. Without having the statute in front of me, the ordinance in front of me, and the Freedom to Walk Act and the traffic section you're referencing, it's kind of hard to give a definitive answer.
Review all those in detail, will you? And then type something up for us. I'd like maybe 3-4 pages on it.
3 or 4
on my
pages,
desk by the end of the week.
And 10 font. I got that for you.
California.
But backwards of pig Latin. I'll get that for you.
No, California's got some real issues to deal with here, right? And the thing that they're dealing with is the Freedom to Walk Act. That's what we're going to
Oh,
make
no,
a
trust me.
priority in the state of
It's,
California.
it adds up. Yeah, it's all compounding. So all the stories you hear are true, but it's definitely compounding with the minor stuff that leads into the bigger stuff.
Yeah.
So I appreciate you guys taking the question.
I feel for you guys out there. I really do. Best of luck to you.
Thanks.
All right. We're gonna do one more. Trevor, you're gonna bring us home. You are able to talk. Ask your question.
Am I good now?
Yes, sir.
All right. So unfortunately, I don't have a new question, but I'd like to go back to the running a gun in a house during a protective sweep.
All right.
So I guess maybe a little bit more context with it, but if you go inside of a house, because I'm good with the entry and the sweep and everything, but my question is, if the person's in custody and the guns are in plain view and there's nothing else, he's not prohibited from having them, they're not evidence of anything, at what point are we no longer welcome to be here? Once he's in custody, you do your sweep. It's not like we can just be in somebody's room and start running serial numbers, for whatever reason, like TVs, radios, whatever, with nothing else. Obviously, if he's, a felon or for whatever reason prohibited, then, that's a different situation. But at what point do we say, yeah, like, no, we can't be in this room anymore, or we have to go back to where he is or start to leave? I think at some point that can become a problem.
I agree with everything you just said, and your point is well taken. Well, our mission for being inside the house in this situation is to find and arrest the subject of the arrest warrant, and then address any safety concerns that are attenuated to or that are associated with that. Once we have addressed the mission, in this case, we found the guy, we've arrested him, we've secured him, we're out. Absent any other lawful basis for being there, you're right. We can't just rummage around the house just to see what else is there. Check out the firearms that are nearby. Once we've addressed any threats to us during the arrest process, we have to pack up and leave. I agree with that.
But did I misunderstand the running of the two firearms that were in plain view are okay to what extent?
To the extent that the arrest process is still going on and we're still securing the arrestee, and we've got everything we need to get this guy out of here. Maybe he's got to put his shoes on. Maybe, I don't know. We're answering questions that the girlfriend might have about the arrest. But once we've done that, you're right. We're done. But if in the process of the arrest, one of the officers, checks the nearby adjoining rooms, or there's a firearm within the reach of the arrestee while the arrest process is still occurring, then we can handle the gun, check the ID. But no, your point is well taken. Once we've addressed our mission, which is to arrest the subject, we're done. Absent some new development of criminal activity. Yeah,
okay, I get what you're saying.
It needs to be contemporaneous with the arrest. So near in time. It does not have to be simultaneous, but right. Let's get it done. Now, can I snap a picture of that firearm when it's laying there? And then as we're walking him out to the car, running the serial number, and then I get back and that pops as stolen. Now what do I need to do if I'm outside?
Yeah, the search warrant.
Probably lock that bad boy down, right? Unless she's still in there. Then do I have an objectively reasonable basis to believe that the threat of violence is imminent? Maybe. Ryburn versus Huff gets me back in, so then I can lock it down and freeze it in anticipation of getting a search warrant.
I got you. Okay.
All right. Thanks, Trevor.
Yeah.
All right. Well, thanks everybody. Appreciate all the questions. Hope everybody had a good evening, learned a little bit. We certainly enjoyed it. Thanks, John, for hopping on. I know you got a lot going on out there.
My pleasure.
We're gonna wrap it up. Say good evening to everybody, and we'll do this again next week. Everybody take care and be safe.